For those of you who have not been here before, the procedures we follow are adjournments are called first if there are any requests for adjournment. Then we tackle the renewals. Thereafter, we get into the cases. The applicant is going to present their case first. Then, if there are any objectants, we allow the objectants to say their piece. And finally, we allow the applicant to sum up, and then we close the cases. Once we close the cases, we don't accept any more evidence. A lot of the cases will be decided today. Some of them will not be decided today. However, if any of you are interested and if the case is decided, you can call Mr. Owens tomorrow. The proceedings are live streamed. We have a court reporter. They are archived. So if any of you want to refer to these proceedings at a later date, you're free to do so. All right, Patrick? We what? I'm sorry.
We have one application for adjournment, case 42123, 42323, Land Beach, Anthony Licatese, also known as 188 Bayside Drive.
Oh, well. How many lawyers we have on the case? Good morning. How can we help you? This one.
Well, I'm sorry, say the name again?
Mr. Minerva? First available date, July 26, 9:30 a.m. 2 o'clock? Okay. 2 p.m. Welcome.
No further notice will go out?
None.
So this is put on your calendar now, there's no more mailing?
They're the only people involved. Any other requests?
We have one more request for adjournment, case 310, 23,
310 or 410?
310, 311, and 312, 23, East Land Beach, 37 Buffalo Avenue, LLC, and Kenneth Kroll, also known as 37 Buffalo Avenue.
Good morning. I feel like a child.
My name is Stephen Landy. You have seen me here once before when you first came in for
Can I just ask you one thing? When you say 2 buildings, do you mean 2 buildings and only 2 residential units?
Correct.
Okay.
Most important, when we were last here, there was a large group of people in opposition, and they were concerned that they wasted a lot of their time. Well, I made sure to make that not happen again by telling them in writing that I would be requesting this application in hopes that, people don't, travel from far and wide to come here.
How many people are here in opposition on this case? I guess you didn't do it too effectively, Counselor. In any event, how long would you like?
We'd like 2 months, surveys, whatever we submit.
Is there anyone here who would like to speak for the opposition?
Only as to the...
Only as to the adjournment request.
Okay,
Come up.
actually, come here because there's no microphone there. Just use this microphone. Name and address for the record.
Robert Devin, 46 Buffalo Avenue, East Atlantic Beach. Just want to know,
Morning.
would we be notified of new plans, with, certified mail? Is this a new application?
Patrick, would you like to address the gentleman's concerns?
If there are new variances, there will be new ones. I would imagine.
But if there are not,
If not, there will be new ones.
We're hoping to continue the existing application and modify it.
And counsel, would you make it a point of including the opposition in terms of submitting new plans and?
We'll upload the course, and I have a list of at least 5 or 6 of the group that I would certainly personally notify.
okay, but when we say notify, hold on. If, regardless of whether there are additional, Mr. Bogle, regardless of whether there are additional variances or not, do they still need to have the new stuff on file within 30 days prior to the hearing date as the old rule?
Yes, we would need to, pursuant to the board's local rule, that would be required to submit that within 30 days should the board desire it. Additionally, if there are no new variances, no mailing is required.
Right.
However, there is a sign posting for subdivisions, so that would have to be updated with the new date. But if there's no new variances, the road department is finding, then there is no requirement to re-notify the mail.
Okay, so as to the folks here, since he doesn't have everyone's phone number and address, and some are here and some were here last time, and we can't, I don't think we can reconcile that very easily. So would it be, as to the folks here who have input of whatever sort, if we set a new date, and let's say it's 2 months from now or whatever it is, and you know that by the time that, within 30 days, before 30 days before the hearing, the materials will be online uploaded. Would that be, I take it that's sufficient for you to know that once it's 30 days before the new date, you will be able to log on and look at all the new materials? Okay? That way, no one is waiting for something in the mail that they don't, then doesn't trigger it, okay? So you can,
I'm even willing to, for the name, I have half a dozen names, I'm willing to email or text some of them to let them know that it's online.
okay, so if it's there before that, you'll shoot a, and those of you who know others who his name he doesn't have, you can let each other know, so maybe it's up there 40 days before the hearing, and you can look at it sooner if you wish.
Now that I've learned with clarity that I have a 30-day problem, I have to get this all done within 30 days of the hearing, or more than 30 days. If we can have early September, that would be wonderful.
I think late,
September 27th,
9:30?
9:30 a.m.
All right, that seems like a good.
Sure.
So the current application was to subdivide property into 3 substandard size lots.
Correct.
So if he can put 2 buildings up, does that change? Is he going to apply for subdividing that?
It's going to have to change the lot lines, et
Well,
cetera, et cetera.
The question is,
Application, it will be larger buildings than was previously requested. Instead of 30-foot buildings, they'll be 45.
but I think what maybe the issue he's getting to, maybe you have answered it, is just because you're building 2 structures, if you're saying, we'll build 2 structures now, but we're going to still carve up 3 lots and later come in, right? So you're actually going to seek to subdivide it into 2 45-footers.
Two building lots.
Okay,
September 27th, 9:30 a.m.
And unless there's new variances, folks, you won't get another notice. You'll change the sign, and at least 30 days in advance of that hearing, the materials will be uploaded online, all the new surveys, plot plan, whatever's changed, right?
We do
have.
that. We
I
do
have.
that,
He has. I've already been there.
okay? Thank you. Have a nice day, all.
Mr. Chairman, do you have a request for adjournments?
Okay. Folks, with all due respect, if you want to have a discussion, if you would be so kind as to do it outside?
First, we have case 406-23 through 409-23, Wanto, Robert and Joyce Green. Renewal of grant for special exception for storage of new and used motor vehicles in conjunction with new car agencies located elsewhere. Grant and waive off-street parking and permission to park in Red
Okay.
District. No sale of automobiles, parcel 3. Renewal of grant to maintain 6-foot-high fence in Red
Fo-
A District. Renewal of grant to maintain 6-foot-high
You wanna-
fence in Business District. Renewal of grant for special exception for storage of new and used motor vehicles in conjunction with new car agency located elsewhere. Waive off-street parking and permission to park in Res A District. No sale of automobiles. Parcel 2, also known as 1886 Seaford Avenue.
Folks, if you're going to have a discussion, please do so outside.
David Cohen, 200 Old Country Road, New York. I'm with the lady in black, attorneys for the tenant on the premises.
Okay.
Mark Zergaville, 3530 Sunrise Highway, Wancho, New York. We are the current tenant of the property.
Good morning. How can we help you?
We're here to, answer any questions with regard to the renewal of these expired permits. The owner and landlord on some of these permits is either Robert or Joyce Green, or 1886 Seaford Realty, which is an LLC, which is owned by the Greens. They were supposed to have sent the notices of renewal to the tenant. They did not, and the permits expired. So we're just looking to get these permits reinstated, no change of use. Just as about the way the Greens are now in their mid-90s, so I'm not terrible.
I'm a little confused now,
We all are.
because this is
This
on
is-
our, go ahead,
This is on our calendar as a renewal.
both of these cases.
We're not aware of the fact that the permits expired.
I wasn't the one who filled in the application, but yes, some of these permits are expired, so we'll be
So-
reinstating these expired.
Hold on, but Joe, if they expired while they were waiting for the hearing date, then for our purposes, they're not really expired, right?
You, time out, Counsel. Wait, has your client received a certificate of occupancy to use this premise the way it is currently used?
I don't believe there was ever a certificate of occupancy. These are vacant lots that are used for
Okay. Has the building department finalized everything, subject to a renewal of the permission by this board?
I believe that's the case. These permits were in place for many years.
And-
there's
Building permit.
When you say significantly, how long have they been expired as far as you know?
It's several years. I can give you the exact date. I can give you the-
It's a 2007 app.
Is it, have some of them under each of the two different names expired, or just one of them?
I believe it's under multiple.
Well, no, the 406, 407, 6, 7, 8, and 9 are permits under Wanta, Robert, and Joyce Green. Under the case 410 is Seaford Realty. Do you know, if you know, do you believe that one or more have expired under each of those names?
I believe that is the case. Again, I can give you the,
Rob, Patrick.
for factual purposes, as I said, the Greens are the owners of the LLC.
This is a Ford dealership, right? Ford? Hassett, yeah, Hassett. Right, and,
Well, wait, is there a difference between his permit
No.
expiring? You think the permit expired, or, so what we're,
you want me to, I know. Sir? Your terminology has caused confusion. That's okay, you wouldn't, you used the word your permit has expired. Okay, now you raised a whole new issue.
no, but that's what he just said.
Okay.
You said that you were issued a permit for one of the properties, and that it never got closed and expired. Is that correct?
These are, I guess, they were temporary permits.
And
They're not-
2014.
They're
They're not temporary permits. The board gives a temporary grant,
But it's his,
and that your permit is subject to the board's temporary.
but he's
It's a little
saying-
different.
He said the permit expired.
No.
All right, so we're just here to address the issue of renewing whatever variances we granted, which may or may not, you may have other things to do in the building department, but we'll just address that issue, okay?
So we're treating it as it was advertised as a renewal. The building department inspected the premises on December 15, 2022, and found that all the previous conditions imposed by the board have been complied with. Is there anything else you'd like to add, sir? No. I didn't think so. Okay.
Mr.
Thank
Chairman,
you.
I would move then that the hearing be closed and that the matter be placed on the decision calendar. Everyone who is signed in on the case will receive a copy of the board's decision by mail once it's rendered.
Second? Second. All in favor?
Aye.
Any
Thank
opposed,
you.
any abstentions? Have a nice day.
Mr. Chairman, next case, Mr. Wilson calls, is going to call for the record, 410-23 Wantagh, 1886, Seafood Realty LLC, renewal of grant for special exception for storage of new and used
Where's that one?
vehicle.
No, that was already.
That was one of the cases, that's one of the cases we just heard. Okay. All right.
Located elsewhere, no sale of automobile, parcel 1, AKA 1886 Seaford Avenue. All my counsel and representatives are already under oath.
Building department inspected this premises on December 15th, 2022, and found that your client was in compliance with all the conditions previously imposed by the board. Do you have anything else you'd like to add, sir? Any questions from the board?
Can I just have you put your name and address on this record?
David Cohen,
With that, Mr. Chairman, I would move that the hearing be closed, the matter be placed on the decision calendar. Mr. Cohen, you and your client and anyone else who signed in on the matter will receive a copy of the board's decision by mail once it's ready.
Second? All in favor?
Aye.
Any opposed, any
Can I,
abstentions?
there's one question, do you know what the approximate timing of that would be?
The renewal?
Yeah, and
As I stated earlier, some decisions are made today, and if we pass on it today, you could probably call the board tomorrow, and you'll get an answer.
very good, thank you very much.
You're welcome.
Have a nice day, folks.
Next case, 411 through 414-23, Oceanside, Shane Saxton, variances, lot area occupied, side yards aggregate, rear yard, maintain shed attached to garage, and overhead roof over, variances, lot area occupied, front yard added setback, side yards aggregate, maintain roof over porch, and pergola attached to dwelling, variances, lot area occupied, side yards aggregate, maintain carport attached to dwelling, variances, lot area occupied, side yards aggregate, maintain roof over second story deck, located at 360 Montgomery Avenue. You swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Take a seat, state your name and address for the record.
Tina Pagliaro, 549 Hempstead Turnpike, West Hempstead, New York, 11552. Good morning, Chairman and members of the board.
Morning.
I think this one is a record for me on the most variances on a property. I'm representing the Grant Family Trust, the seller of the property, and Shane Saxton, the new owner of 360 Montgomery Avenue in Oceanside. The property is located on the north side of Montgomery Avenue, 80 feet west of Yost Boulevard in Residence D. We're requesting a variance to maintain a roof over a second-story deck that violates the lot area occupied, side yard, and side yard aggregate. The lot coverage allowed is 27.5%, and the lot coverage
So the rear yard is only on the one, and that is 11.7, right?
correct.
And then your shortest aggregate's 9.1, your shortest side yard's 3, right? And lot area is 40.
Correct.
You've submitted photos, and it looks like the pergola is almost on the property line, in the front of the house, like an extension of the porch. what's the setback of this to that, and is this a pergola?
That's one of the pergolas.
That's what I think.
You can angle, I think you can maybe see it better from this picture. That's in from where the second story deck is. Yeah.
What is the, so the board granted the deck and then your client put a roof over it?
That's correct.
Flying pergola.
What is the setback of the deck to the property line?
3.2.
The deck with the roof over is 3.2?
Yes.
And the pergola's 5.3.
And the board, it looks like the opposite. And the board granted the deck with that setback,
Correct.
3.2.
What year?
Yeah, when was that?
1989.
Make sure I wasn't here. Move that hearing be closed, the matter be placed on the decision calendar. Ms. Pangallo, you'll be notified by mail of the board's decision once it's rendered. Aye. Ms. Pangallo, and as you know, because you do this a lot, the Board of Architectural Review always reviews any requests for immediate family or mother-daughter residence. They, from time to time, make recommendations and/or opine that it is otherwise appropriate. In the case of this application, the Board of Architectural Review has determined that this residence is suitable to be used as a mother-daughter residence, and it is restorable to a single-family residence at the cessation of, so you don't have to worry about that. Hearing be closed, the matter be placed on the decision calendar. Ms. Pangallo, you'll be notified by mail of the board's decision once it's rendered. Thank you.
Very much.
So entitled in Residence B is 27.5%.
Yeah, the deck would, that 30 is only allowable if the deck is much lower. So at the height of this deck, it's a 30. The comparison is a 27 and a half. Right.
So what's the height of the deck?
Well, it's bi-level, so I'm assuming it's below what? I don't think it's, well, I don't think it's the 3 feet. Isn't it like 8 inches where you get the 30?
Yeah, so what the,
What is it doing? All right, but if it's a 3 feet high deck, we compare it to 27, not 27 and a half, not 30, right? Tell us, Don. We use 30 even when the deck's high.
well, it would be, the coverage of the 3-foot deck would be included in the calculation. So it's
Right,
not,
of course.
it's not just if there's any deck, it's if the deck covers 2.5% of what the lot area would be, that would be included in the 30 if it's greater than 3 feet.
Okay, so we're comparing it to 30, is that what you're saying? Okay.
Evidence. We'll accept it. Can I see it? Oh. Part of it is, part of it isn't. Yeah. Maybe this will take a peek. I knew sooner or later we'd be subjected to the same kind of freezing temperatures we were in the other. Just doesn't get much worse. Yeah, my hands are cold. It's the usual.
How much of the lot coverage, what percentage of the lot does the deck cover?
So, the current existing home is 32.22%.
So the deck's 7%.
Right, so that would be included in the 30%, which is greater than 2.5%. Which is if we're getting extra, you're allowed to have a lot coverage.
All right, let's just finish the case.
How is it that it's 32.2% now? Did it have a variance at one point?
No, so there's a current existing deck that is going to be removed,
No, he means the house.
but that is not permitted. So that current deck is 525 feet.
Is that 525 feet included in the quote-unquote existing 32.2?
Yes.
Wait, I thought that
So
the
you
third,
don't, Does that deck have a permit, the existing deck? So this is really, with all due respect, this is kind of deceptive that it's 32.2% because that includes an illegal structure.
Wait, she said that, but didn't you tell me that the 32% coverage was the house only? My question earlier
Not what you
was,
just said, but-
no, but my question was, what percentage of the lot is covered by the house? And you said 32%, so,
I'm sorry, I gave you the existing current lot coverage, so.
okay.
deck-
How big is that? Is that, you said 500 square feet is a deck?
The current deck is 525 square feet, the proposed is 539 square feet.
Same size, just about.
Changing the existing lot coverage from 38.79% to 39%, so 0.21% difference with the new deck.
So this is the house? That's the deck. It's got a lot of shrubs, so I guess it's hidden. See, initially I was doing the math, it's an 8,000 square foot lot. It's an oversized lot anyway, now they're more and more and more. But it's protected.
Yeah, I think the deck is 7%.
Any other questions or comments from the board?
Not for me, sir.
Can I have a motion?
Move the hearing be closed, the matter be placed on the decision calendar. Mr. Love, you'll be notified by mail of the board's decision once it's rendered. Thank you, have a nice day.
Can I have a second? All in favor?
Aye.
Any opposed, any abstentions? I thought we were pondering, I thought we were continuing to ponder something else. I didn't, I'm sorry.
Next case, 418 to 420,
Yeah,
23 Ball.
percent, I get it.
and Sogstead. Variance is lot area
Joe was
occupied,
concerned with the lot
lot
coverage. I don't actually care, 'cause it's
In the
back.
back.
Variance is lot area occupied, side yards aggregate. Construct second
Some of us feel it's a wee bit too chilly. But go on. I digress.
Requesting relief from the board in regard to 3 variances. They are for his address at 118 Beach Place. The variances are for a proposed deck, an existing rear shed, which is truthfully an addition to the home, and a front stoop with a portico. Mr. Stogstead and his wife have lived at their home since 1997, and during the course of living there, right about 2002, Paul is a general contractor. He made adjustments. The shed in the back of the property actually did have a permit, we believe from 1995. It was prior to his purchase of the home. The previous homeowner had cleaned up shop with the property. What Paul did was he changed that structure. He raised the roof and put a reverse gable as opposed to the shed that you currently see. He feels it was done to the exact size that it was at the time that was granted. As far as the front stoop goes, Paul had put brick surfacing over the existing stoop, technically increasing the size of it by about 4 inches on both sides. He also put a roof portico with columns on top of the stoop. The deck in the back of the dwelling that's currently there did also have a permit, and he wants to replace it with a deck that will not only be one that has a spiral staircase that is unfortunately encroaching into the side yard by 2 feet, because we have a minimum side yard allowance of 5 feet. The staircase will reduce the side yard to 3 feet. Part of that deck level will also have a screened-in porch. Paul's property is right on the water. It's a little bit buggy, so he would like to do a screened-in porch. You're probably aware that the home is a high ranch, so the way that this is played out for that deck is that it's for the proper first story of the home, which on a high ranch is really the second story, if you will. The goal is to create an area where Paul and his family can enjoy their backyard better. They currently have concerns that the deck that's installed back there now is on its last leg. This project started with Paul back in 2004 when I was employed with a different architecture firm, and it was originally just to create the deck. And you know, Paul is a very reputable builder, and we had that moment where we realized there were items that maybe would need permits. And here we are today because those items also needed variances. We needed variances for lot coverage and for side yard encroachment and for side yard aggregate. Maximum allowable lot coverage, as you see in our plans, is 1,650 feet. We're asking for a little, it's just a smidgen over in excess of 2,800 square feet, about 650 over the maximum allowable, if you will.
Percentage, Mr. Trentadue, 38.34? Is that your max?
The allowable percentage is 27.5%. If the deck were at a 3 feet or lower level, it would have been up to 30%. The percentage that we're seeking relief for is 38.34%.
Okay, and as it relates to the front yard average setback? You,
I do apologize, I didn't mention the front yard setback.
no, you kind of did, okay. So you said that there was an existing stoop of some sort, your client covered it, which enlarged it slightly, and then added columns and a portico over it, or something like that. Okay, and that's probably your largest encroachment, if I read the documents right, 18.6 is the average, and you're proposing 9.7. How much further into the front yard setback did your client go when he made the alterations? Not significantly,
No, he wasn't aware of the front yard setback ruling.
No, I just want to know how many feet.
The encroachment is truthfully 9.7 feet to the first proper stoop height, if you will.
I know, but how much of that stoop,
How much of the
How-
encroachment?
How much was it increased?
how much further into the front yard setback, maybe your client can answer, did your client go when he made those minor alterations? So even if you... So had you not done that, you'd be here seeking something very close to what you're seeking now? Okay, and that step that used to be there, before you altered it, that was the step, or the front porch, or whatever it is, that was there when you purchased the house in 1997? Okay. Okay, and the closest side yard encroachment is down to 3 and 13.63 on the aggregate. That's the...
I want to just make another point. The screening area
We'll accept those in evidence.
You take the photos, Mr. Trentadue? You took the photos, right? Okay, and the chairman's already accepted those into evidence.
You'll see that the alterations are really not magnificent in any way. The rest, yes.
Do you have any kind of a building on the waterway? Right.
The kind you can put up and take down.
Okay.
It's temporary.
There's a history of other permits that are in the process of being approved or have been approved. One is the pool and the enclosures.
The pool is not approved yet?
No.
It is approved. I don't think he's paid to approve it. If he wants to do it all at the same time so that they don't expire.
It's an open permit, Joe. It's one of many.
Sandy damage permit that we put in for. There's also a fireplace in the room that was approved, and I believe that
Did-
one's in.
Is it necessary, and have you obtained permission to put that dock on the water, a permit by the Department of Conservation and Waterways? It does, issued by the Conservation. Okay, thank you.
If we are if we approve this, it sounds like your intention is, and you need to, close all open permits, right?
Said that.
The only reason we hadn't done that was by virtue of the
Said that
duration
in
of
the
time we
decision.
usually get from
Not okay.
as far as
It's okay.
Last point I want to make is the shed. It's attached to the structure. It's unfinished on the inside. You do see skylights in the photos. As I said, Paul is a builder. There are things he gets from projects that he chooses not to discard and parts that he can. The inside of the shed is unfinished. He uses it for boat equipment, any recreational things for the pool. You know his house is a high-range community. It is in the flood zone. There is no basement, there's no storage for that. So that's why he continues to have the appreciation for that space that he has.
Anything else, Mr. Trentadue?
No, just the last comment I'll make is that the neighbors to the left, another neighbor to the left, and the neighbors to the right, and the neighbors across the street have no opposition to this project.
Any other questions from the board?
Mr. Chairman, I move the hearing be closed, the matter be placed on the decision calendar. Mr. Trentadue, you, your client, and anyone else who signed in on this case will receive a copy of the board's decision by mail once it's rendered. Thank you, have a nice day.
Second. All in favor?
Aye.
Aye.
Opposed?
Next case, 424-23 Woodmere, along the Lehman, variance is not area occupied, side yards aggregate, construct addition, and enclose existing porch, both attached dwelling, located 933 Midway.
I thought it was.
Paul Biegler, located at 129 Valley Boulevard, California. He is to present a case for Ron Medina. There is single-family split levels located on the south side of the way, 89.29 feet west of Northern Way. They are proposing to enclose the front porch, which is permitted by code. And they have, proposing a rear addition. Okay, the rear addition, in violation of the, lot area occupied and side yard and side land. The lot area is permitted is, 27.5%. This is in a residence B zone. It's 27.5%. And we're proposing, the lot area of 32.5%. The side yard is 4.92, where a 5-foot minimum side yard is required. And the side aggregate is, in the front it meets the aggregate, but in the back, front line of the house meets the aggregate, but the back of the house, because the property is on skew, it's at 13 point, actually 14.7.
Where the required, for some reason in your case, is a percentage, so it looks like side yard aggregate required here is 18.22, that's what the chart says. proposing 14.
Any other questions from the board?
Move the hearing be closed, the matter be placed on the decision calendar. Sir, you'll be notified by mail of the board's decision once it's rendered. Thank you.
Second, all in favor?
Aye.
Any opposed, any abstentions?
Next case, 425 and 23 Seaford, Linda H. Halford, mother-daughter residence, second kitchen, located at 2180 Seaford Avenue.
Thank you.
Thanks. Nah. Ahead.
Oh, you got it. Did you get her name? Can you do it again? Loud as you can.
Linda Telford, 2180 Seaford Avenue, Seaford, New York. Tanya Telford, 2180 Seaford Avenue, Seaford, New York.
Christos Elias, 2180 Seaford Avenue, Seaford, New York.
Good morning, distinguished board, my name is Michael Dagan, registered office engineer, Monterey Avenue, Monterey, New York. I'm here with my client, Linda Telford, and her daughter and her son-in-law. Linda purchased this home in 1984 with her now deceased husband, Tammy, was actually born in this house, raised, and married Chris to my right. They're seeking a variance for a mother-daughter second kitchen. Linda has secured letters or 4 signatures of support on behalf of the variance. We'll present as Exhibit A.
Okay.
Accept that in evidence.
The second kitchen is existing, was installed as part of the 2019 renovation. Linda, Tammy, and Christopher are the sole 3 residents of the home. The 3 family members share 2 cars, and they're both easily fit in a double-wide driveway. The house is located in walking distance of the one-house road. They are aware that all cars should be kept off the street. There is only 1 electric meter, 1 gas meter, and if they were to install a doorbell, they understand that there would be.
Your clients received the mother-daughter fact sheet. You familiarize them with all the conditions?
Yes, I share this with them. I have their present.
Yes.
Give me 1 second, I'm just trying to find a certain document.
Looking for the BAR.
That's the house.
No. You have some other open permits, you're aware of that?
Yes, so there's an applicant, I mean, you want me to recite them? Or-
Yes, please.
So the application 21-15425, this is over here for maintaining existing kitchen for mother-daughter. Also 22-9570, to maintain kitchen sink and dishwasher. As part of this process, the zoning board asked us to also provide application for a PVC fence, which is in with the building department at 23-4725. And in addition, there's an existing shed, which is on the application 43-4726.
You appear to have an open building permit for the garage?
There's the open building permit on the garage that was constructed in 1957. We assume that under part of the 2019 renovation, which included a rear
It's a nice looking
addition to
house.
that garage, and other work that was completed with the house, as part of the final inspection, it would be typical protocol for the building department for the final inspection to observe and sign off on all of, the balance of the outstanding open permits.
Oh, I guess her dog.
Shows that it's open in the building department. Maybe you want to check that out, because if your clients go to
We can
sell
look
it,
at our neighbors' houses.
and it appears, if your clients go to sell
your
the home and
house?
it appears that there's an open building permit, that may be a problem in the future. So maybe you want to go up to the building department and talk to them about that? If it's been signed off, get it closed out. Okay. All right.
Whenever we have an application for a mother-daughter use and/or an immediate family use, the Board of Architectural Review also reviews it to make sure that it's suitable to be used in that manner, and that it is suitable to be revert back to a single-family use upon the cessation of the mother-daughter / immediate family use. In the case of this application, the Board of Architectural Review determined that it is in fact suitable to be used as a mother-daughter, in a mother-daughter use way, and it also is suitable to be converted back to a single-family residence upon the cessation of it, that use, with the caveat that there be no illegal occupancy in the cellar, basement, whatever you actually have. So, there you go.
Any other questions from the board? If not, do I have a motion?
Move that hearing be closed, the matter be placed on the decision calendar. Each of you who have signed in will receive a copy of the board's decision by mail once it is rendered. Thank you for coming and being patient as the last group today.
That concludes, second, all in favor? Any opposed? That concludes the morning calendar. We will take a 5-minute break and then come back and hopefully make some decisions.
As to where we're going to eat lunch.
We can eat dinner, and it's so early.
You could eat breakfast.
Yeah, I might. When's the afternoon case? All right. What is this? How come nobody takes a photograph of us? In any event,
All right,
decisions.
let's go.
Let's look at these.
Cases 406 to 409 Wantaw, Robert and Joyce Green. Do I have any comments from the board? If not, do I have a motion?
I move case 406 to 409 of 23 Wantaw, Robert and Joyce Green, at 1886 Seaford Avenue be approved as requested.
Same
Same
conditions.
conditions, 5 years.
5 years.
Of course.
Second.
All in favor?
Aye.
Any opposed? Any
Okay.
abstentions? Case 410 of 2023, Wantor, 1886 Seaford Realty, LLC.
I move case 410 of 23 Wantagh, 1886 Seaford Realty at 1886 Seaford Avenue be approved as requested.
Second.
All in favor?
Aye.
Any opposed?
Same,
Any
yeah, I
abstentions?
was just
Same
gonna say.
conditions, 5 years.
Yep.
Cases 411 through 414, 2023, inclusive. Oceanside, Shane Saxton. That's the OK Corral case. Do I have any questions from the board? Any comments?
I move, Mr. Chairman, that cases 411 through 414 in Oceanside, as you've previously described them, affecting the property at 360 Montgomery Avenue, be approved as requested with the usual shed and other conditions applicable.
Do I have a second?
Second.
All in favor?
Aye.
Any opposed? Any abstentions? Cases 415 and 416 of 2023, Seaford. George J. Giandrea and Lori Pfister, co-trustees of the Loretta E. Giandrea Family Trust. It's a mother-daughter case. Do I have any comments or questions from the board? If not, do I have a motion?
I move that case 415 of 2023, the mother-daughter aspect of this companion, or these two cases, that it be granted in accordance with the usual mother-daughter conditions, and that case 416, 2023, maintain the rear deck attached to the dwelling, be granted as requested.
Do I have a second?
Second.
All in favor?
Aye.
Any opposed, any abstentions? It is so nice to hear your voice, Mr. Pellegrini.
Yes.
Case 417 of 2023, East Meadow, Shelley A. Satinstein. Do I have any comments or questions from the board? If not, do I have a motion?
I move case 417 of 2023, property located at 1460 Cleveland Avenue, East Meadow, be granted as requested.
Do I have a second?
Second.
All in favor?
Aye.
Any opposed, any abstentions? Is it Satinstein or Satinstein?
I would say sentence.
Did anybody ever see Young Frankenstein? Frankenstein. Okay. Next cases, 418, 419, and 420 of 2023, Paul M. Saugstead. That's the case with numerous open permits. Do I have any questions or comments from the board? If not, do I have a motion?
I move case 418 to 420 of 23 Baldwin Paul Sogstead at 1118 Hayes Parkway be approved as requested, close out all the open permits.
Do I have a second?
Second.
All in favor?
Aye.
Any abstentions? Any opposed? If, all right, cases 421 through 423 of 2023, Atlantic Beach, Anthony Licatese. That case has been adjourned to July 26th at 2 o'clock.
Yes.
We don't have a morning.
We're going to do this, 2
When
o'clock.
when did we put that on the
Yeah.
Oh, it's filled? Oh, okay. All right, case 424 of 2023, Woodmere, Ilan Molina. Do I have any questions or comments from the board? If not, do I have a motion?
My turn?
It is. 424 of 23.
Okay, yes, Mr. Chairman. I would like to make a motion as relates to case 424 of 2023, Elon Molina in Woodmere, affecting the property at 933 Midway. I move, Mr. Chairman, that the case be approved as requested.
Second.
Second?
All in favor?
Aye.
Any opposed? Any abstentions? Case 425 of 2023, Seaford Linda H. Telford, mother-daughter. Do I have any questions or comments from the board? If not, do I have a motion?
I move that case 425, 2023, Telford be granted, mother-daughter be granted as usual mother-daughter conditions.
Do I have a second?
Second.
All in favor?
Aye.
Any opposed? Any abstentions? Okay, 9:30 adjournments. East Atlantic Beach, cases, 310, 311, and 312. Those cases have been adjourned to September 27th
At 9:30.
at 9:30 a.m. How about 9:30 p.m.? All right.
It says honorary Irishman.
That concludes the morning calendar. What do we have on reserve?
Mr. Chairman and members of the board, concerning case 199 of 23, the Starbucks there, I did receive an email correspondence from Bill. Starbucks is sending their engineers apparently this month to redraw the plan, but they're dragging their feet in a, there's a lot of corporate bureaucracy there.
We'll hold it.
Related to 222 and 227, I've made multiple efforts to reach out to the council, or the applicant in this one, he was represented by council, concerning the matter of requesting a reopening of this matter for the variances requested. At this point, I don't believe it is useful holding this matter on the calendar for the renewal. I do believe that the only way we might be able to get them to come back in is either we give them the relief being requested at 5 years renewable, or we deny it and make them come in to legalize what they said they were going to withdraw back in 2010. So I don't know what the,
Give them a shorter term renewal.
excuse me?
Force them to come back with a shorter term renewal.
That also works. If the board's comfortable with that.
Any suggestions about how short a term renewal? How about a year?
I was thinking that. I think
How
that
about a
was-
year?
I said I would do a year.
Okay, somebody want to make that motion?
And then you can explain when a lawyer
Yeah.
flips
Why?
out a little bit, or
Why?
you could say we want
That's
them
right.
to make an application.
Come on, come on.
I move that case 222, 227 in Seaford, the Spot Restaurant, DBA Parkside Cafe, at 2479 Alder Avenue in Seaford be granted for a term of 1 year.
Do I have a second?
Second.
All in favor?
Aye.
Any opposed, any abstentions?
Concerning East Rock Development, I did provide the board with a draft decision on this, apologies, the portion of which would be dismissing the front yard average setback request as it's barred under the doctrine of administrative res judicata, and denying the rear yard setback. It is a matter of first impression. I don't know if the board has any comments. Findings were provided with that as well, stating basically our legal authority pursuant to case law and statute.
Do I have a motion?
I move that case 160, 2023, that the draft grant that Mr. Bogo's put together pursuant to the board's direction be adopted.
Do I have a second?
Second, but it's
All in favor?
Aye.
Aye. Any opposed, any abstentions? Well
It's
done,
dismissed.
Mr. Vogel. Next?
Isn't it a grant and
Yeah.
a denial?
No, it's,
No, he adopted the draft, sorry, he adopted the draft decision.
right,
Yes.
right.
It was a
It was-
dismissal.
Draft,
That was-
yeah.
Decision, correct.
Is that,
Yeah.
yeah,
It was dismissal and denial.
Mhm.
grant the draft.
Any others on reserve calendar? Any others that we should be hearing about?
Yeah, there are a few. Pat, do you have the next, you have 274, do we have anything on that?
274, we're still on hold, we're still waiting for plans showing the doors and rear.
I think the draft
275.
For 265, I did receive, yeah, no, that's fine, but just to add on top of that, Mr. Avertine has submitted a request for a reopening on this matter to submit further evidence. He did provide a check for 250 statutorily, so it needs to be considered. We can do it there in the administrative calendar if we want. This is 265 of 23.
This is the elevator,
Elevator.
the elevator up to the roof.
I'm on the wrong page.
Okay.
Yes.
Yeah.
Because that was a request from the...
Any others?
Yes.
17?
For New York Land Development, that was the incredibly small legalization of that parcel. We weren't able to act because we didn't have a supermajority. I don't know if the board would prefer to make a decision on it now.
Any comments from the board? My recollection was there were a lot of people in favor of that.
There were the entire neighborhood was in favor of that application, at least those who showed up.
Okay. Yep.
Yeah, top of page 2.
Anybody want to make a
317.
motion?
So I move case 317 of 2023, located at 75 feet west of Stevens Street in Roosevelt. I move to grant that request.
Second, all in favor?
New home.
New home
New home
conditions.
conditions.
Owner occupied, right?
Yes, owner occupied, no cellar entrances, the usual conditions.
Second, all in favor?
Aye.
Any opposed, any abstentions?
Yeah, I did provide the board with the draft grant in the Papio Development Corp. case, basically confirming the NCPC recommendation for a two-lot subdivision. Mr. O'Brien also provided a composite map, which I provided to the board, showing how those two parcels would be subdivided.
Any other comments? Any comments from the board? If not, do I have a motion?
I move that case where am I? 257, 2023, 258, 2023, and 259, 2023, that be a draft grant.
It was a draft grant to be
Draft grant to indicate that the board will approve 2 dwellings on this parcel, and that they be so located to prevent a third to come back in.
The way it's drafted is 257 and 259 would be granted, 258 would be denied,
Got it.
and 257 and 259 would take the tax lots from 258 to create a 39 by 80-foot parcel as opposed to 220,
That's
yes.
perfect, thank you.
Second,
Second.
all in favor?
Aye.
Any opposed, any abstentions? What else?
And that's you. Do you have anything on that one, Pat?
Don't have
Oh, no, I don't think, no, we talked about this yesterday. They didn't provide any new plans for this one.
For
And
which
as
one?
For 355 to 357, 362, and 366, we did send out the building department. They haven't gotten back to us yet, have they?
Okay, so we're going to hold them.
Yep.
Hold them. 242? Anything on that?
Oh, I would like someone else to go and look at that also. in Woodbury.
Lawrence letter, yeah.
Okay, fine.
I'll go look at that. All right, hold that.
I'll look at 300.
As for 371, I did provide another draft to the board. In this new draft, I included a section 1. In conversations with Mr. Pellegrini, and something in which I agree on, is that the portion of the application requesting an accessory structure ancillary to religious use, which is the rental property, was improperly before us, as it is not accessory to the religious activities and is more of a mixed use, in Joe's words, which I agree. So the portion of that decision was modified to have a section dismissing that without prejudice, so they can come back for the religious, for the mixed use, for the business use. And the rest of the application would be similar to the previous one, which is granted 1 year, temporary, need to provide a permanent structure, a plan for a permanent structure on the premises, that they are good faith efforts to pursue the usual language that we had in the previous one.
Do we want, does someone want to make a motion on that?
Maybe we could do that in the afternoon.
Okay.
PM. PM. Okay.
I believe this is when we were waiting on the NCPC determination.
Hold on a minute. We have another case on Bayside Drive in Atlantic Beach. No one would grant me.
Okay, this case was just, we didn't have the NCPC.
Which case?
Sorry,
382?
23, we did not have a determination from the Nassau County Planning
Okay,
Commission.
now we have it.
Correct.
Did anybody look at it? Was there a need to look at it? Since it's right down the street from the other one. Hello? Are we listening? Did anyone, is there a need to look at this? Does anyone have any recollection? 382 of 23. It's at
Bayside Drive.
Atlantic Beach. It's right down the street from the Licatese case. Do you want to refresh your recollection? We'll hold it for another 2 weeks, and just in case. PM. PM, please get the map.
I can even probably look at it on the thing, see.
391?
Yeah, so I provided a draft grant to the board in which it specified that this was previously granted under permit number back in 2001. However, I spoke with Mr. Pellegrini about this, and I think it actually might be a better resolution on this. If we're concerned about precedential impact, this case is still pending under the same permit number for the same exact relief. They had to come back because their time for an extension of time, oh, and also for an extension of time, they technically could have pursuant to 271 because certificate of completion was never gotten, but they completed the building. So there is no time bar on requesting an extension of time if the building is actually constructed. If you don't get a permit or don't commence construction, there's a time limit. So I believe the most proper thing, so we don't set a precedent, it would be relating back to the original grant, would be to dismiss the case as moot and adopt an extension of time of 1 year, renewing the permits that were issued back in 2001, and that way it's the same exact building, no relief or further relief was requested, and we don't have to worry about setting a new precedent regarding height, because the height was measured differently back in '01.
Oh, this is that case?
Yes, exactly.
That was legal when it was built?
Built.
Right, but they completed the structure, so they couldn't come for an extension of time. The building department instead was concerned about the height and just denied it.
Okay, but I just want that, the decision to be very, very clear.
Here's the
That we're not granting a height variance.
This is the decision. This is going to be dismissed, and we're granting an extension of time for them to secure the permit.
Oh, okay,
Certificate of
so we
completion,
never
so-
have a
Yeah.
grant of height.
Exactly, it's the grants back from '01.
That's great.
Exactly,
Okay.
that's the resolution.
Can we make that motion? Someone, please?
I move that, as it pertains to case 391 of 2023, that the applicant could have and should have asked for an extension of time. Therefore, case 391, 2023, that be dismissed as moot, and that the board grant an extension of time for the applicant to secure the final certificate of occupancies and whatever else is necessary pursuant to our building zone ordinance.
Second.
All in favor?
Aye.
Aye.
Concern to 395 of 23. I had a question to the board of this one. If they recall, this is the house that wasn't a two-family, but the stairs were located down the middle. I was directed to do, I guess, a draft grant. I just didn't know exactly what language the board would want to include in that. We can do, for example, we can do a maintain conditions and just have a condition that says that one of the units shall never be converted into, have a second kitchen. It just seems like it's general language. I just wanted some specificity to prevent them from possibly converting it to a two-family. I thought it was practical. It's just that I don't know what language we want to put in there, that besides saying, can't put a second kitchen.
Portico case.
Yeah, the staircase is located in the middle, so it kind of looks like there's two units, but the other one doesn't have a kitchen. It's basically a brother and sister. Oh, yeah, it's a brother and sister.
I remember, this is the one where the guy said the email that was to the wrong address.
To the wrong address, correct.
Yeah,
Maybe not, maybe not a second.
yeah, you're already done.
But if they don't,
Oh, this is the one where this is the one, can we pull the plans again? I agree that the portico's wrong, because it is set up like literally so that in the portico you put a door or two doors. That's the whole problem, that's what they pointed out, and I happen to agree with that assessment.
Next case, 402 of 23.
all the plans.
Pull the plans.
We'll resolve that.
Oh, same thing on 402. There was no NCPC determination at the time. Now there is.
Yeah, it's made now. Does somebody want to make a motion on this case? We now have
It's
the
402 and 403.
NCPC determination.
Okay, I will. Mr. Chairman, I would move as it relates to case 402 of 2023 and 403 of 2023 in Baldwin, property located at 1849 Fargo Street. It's a request for a subdivision and a few other minor variances. I would move, Mr. Chairman, that we grant the applications as requested with the usual subdivision conditions and making each unit owner occupied.
I have a second.
Second.
All in favor?
Aye.
Any opposed, any abstention? Same for 40323? Rob?
Correct. One second, no. Oh, same for 403, yes, same for 403 and 20.
Do we want to have a motion on that one as well?
Oh, she made a motion on both 402 and 403, right?
You did? Oh, okay. Okay. 404. You wanted to review the previous hearing, Mrs. D'Amato. Which one was this? Rob, which one was this?
We emailed it to you, I also have a hard copy.
Is this, which one?
Is this the one? Oh, this is the one that might.
I might have it in my car.
Okay. PM if you have it, if not, we'll hold it.
Yeah, this is the one.
PM if you have it in the car.
Yeah, this is the one where we denied previous subdivision in 2006.
Right.
This is an interesting one, yeah. Yeah, you want to talk about it in the afternoon? Or? Yeah. I know. The last one, yeah, 374 and 380. We provided the board with the list of conditions that Mr. Panesso said he'd agree to. Outside of that, there was no other holdup as far as I know.
That was the Puerto Campera?
Puerto Paris, yeah. Chicken place.
They agreed, yeah, we submitted a couple conditions as well as he was moving one sign that was south facing to the west side of the building.
But that didn't trigger any variances, because you're allowed one wall sign, and that was the one that was permitted as of right. They put a second one up, but that's not permitted.
Yeah, Mr. Chairman, I will make a motion as it relates to cases 374 of 2023
Wait. Oh, there is a, I'm sorry, go ahead.
through 380 of 2023 and Merrick affecting the property, it's the application of Merrick 1808 LLC affecting the property that has, 1808 Sunrise Highway in Merrick. I move that we grant the application as requested with the usual conditions related to drive-through windows and parking and
Second.
the signs.
Signs 5 years.
Uh,
5 years, 5 years for signs. Yeah.
Anything on any of the cases on page 6?
Nothing in the referral calendar.
We can hold those. Hempstead.
Yes. The, First is the extension of times. Congregation Aish Kadesh granted back in November 2022. It's the secure permits. It was recently granted. First time on the extension. They are requesting 1 year. This is Congregation Aish Kadesh, religious use, the extension of time. First time on time. Apparently they're still going through plans. Yeah, going through plans to build a park. That's the excuse. We didn't really specify too much.
Mr. Chairman, as it relates to case 546, cases 546 through 549, Congregation Ashkadesh, I don't know, I hope I said that right. The grant was originally made on November 2nd of 2022. They've had no prior grant extensions of time, and they requested an extension of time to secure their permits as they are still working with the building department as it relates to the plans. I would move that we grant them a year? A year.
Do I have a second?
Second.
All in favor?
Aye.
Next, I have a request for reopening concerning the ISO matter that is currently on our reserve calendar. We received a letter from council. It is an official request. We received a letter from council, as well as a statutory fee requesting that it be reopened. Argument being that we believe that the opposition testifying as to certain ways to access the roof was an expert, who could testify accordingly. So we wanted to submit further evidence, basically supporting that there is no way up there besides the other.
I would say that, number one, the neighbor who testified was without counsel, but did state for the record his background. While we did not formally recognize him as an expert because the request wasn't made because he's not an attorney, in my opinion, he sufficiently stated a basis to testify as to what he believed was available. And arguably, it may not have even been opinion testimony in a way, because the basis of his testimony was that he was involved for several years, I think he said 7, but 7 or greater, in the sale of medical equipment. And he testified that from his experience, that he was familiar with equipment, that multiple types of equipment that could transport individuals up staircases, around corners, and all of that. So I think his testimony should be accepted as it was. I think the applicant, being the individual, the person who came before the board, asserting a claim that an elevator was necessary to get upstairs, had the burden to provide testimony as to how that is the only way, and did not do so. So I think it's a waste of the board's time, and I don't think it's fair to pull the neighbors all back in here because the applicant wants another bite at the apple. While Mr. Abertine is a very, very good and competent lawyer, I think that he had the opportunity to make his case, and I don't think we can continually have people come in and say, oh, you know what, I didn't present as much stuff as I wanted to, so can I come back again? So my opinion is we should deny the request for a rehearing, and Mr. Abertine can just proceed however he sees fit otherwise.
Yeah, it has to be unanimous, and it's also absolutely discretionary. He's not entitled to any sort of retest in the record. So, by duty.
I move we deny the request. We deny the request for rehearing.
Second.
Aye.
Aye.
The last one I have is, if the board recalls, this was the Solomon case, located at 72 Central Avenue in Woodmere. This one, we denied the basement kitchen, the second kitchen for the Passover kitchen. In our usual conditions, when it comes to new homes, we have general condition of no basement or cellar access into the basement. She, in her plans, it was legally there, nothing in the building permit denied the cellar entrance proposed on the application. However, because of our general conditions, it was excluded from it. I will say, from looking at the plans, the size of the structure, I don't believe this is something that would be risking being transferred to a two-bedroom.
Right, we need to remove that.
But she wants a modification to remove the condition, if it's amendments. Case number
I'll make the motion, you guys can decide.
382, affecting 782 Central Avenue.
382, Mr. Chairman, as it relates to case 382 of 2023, and the request by the condition that we grant the request to amend the condition to remove that preclusion.
Second.
Aye.
But we're still holding,
On the merits, we're working
Yes.
on the language